This is Rachel from the O'Connor Law Firm. We're here answering some questions. The first question submitted on our Facebook page was, on the First Amendment, what are the lines between free speech and defamation in the new age of the internet?
I'm Matt O'Connor with the O'Connor Law Firm PC, Mid-America Trial Lawyers here in Kansas City, Missouri. So the question is, what is defamation and how does it relate in the age of the internet to the First Amendment? Like, the best place to start would be reading the First Amendment. A lot of people may have opinions about the Constitution, but before you express your opinions, you might want to educate yourself on what it actually says. And it states, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of peaceably to assemble and to petition the government for a redress of grievances. Now, let's skip the establishment of a religion and the free exercise clause. Basically, really quickly, that basically states that the government cannot create a state church. That was the case in England, so they wanted to prevent that. So there's no state church, and you can't prevent people from exercising their religion. Now, as it relates to the freedom of speech, what this says is Congress cannot make any laws that limit or abridge the freedom of speech or of the press. And that's what the First Amendment states succinctly. So how does that relate to defamation? Well, you have the right to free speech, but you don't have the right to harm other people using your free speech. For example, if you say that John Doe is a criminal, and that is not true, would that be defamation? Absolutely. And here's why. Defamation consists of elements, and in law we talk about elements. And to make that sound a little less legalese, it's like baking a cake and their ingredients. Okay, you have to have flour, sugar, etc. So in a defamation case, there's going to be things that you're going to need to have. 1, a statement that is false. 2, an injury. And 3, a knowledge by the speaker of the statement that it was false. So in other words, if I know that John Doe is not a criminal, and I state that, then he doesn't get a job, or it affects his ability to earn a living. Let's say he's in sales, things like that. Those are damages. So in any civil case, a tort, often called, or a personal injury case, or an injury case, you look for these elements. That is, what is the cause of action? Is there a legal duty that the defendant has broken? And are there damages? And then, practically speaking, can you recover and who from? So oftentimes, let's say it's an auto accident case, let's say someone was speeding, the person was injured, and as a result of that injury, then they had to seek treatment. Those are the damages. And who would you recover from? Oftentimes the insurance company. Now, as it relates to defamation, the person making the statement would be the person responsible for taking care of the damages. Now, if you think that, for example, if you post something on Facebook or in a chat room or on a third-party website, Congress, when the internet was still in its infancy, created a law which basically gave those third-party providers a level of immunity. So in other words, if you state in a chat room or on Facebook something that is untrue or that defames someone, Facebook can't be sued. That doesn't mean the speaker or the person who wrote the defaming comment can't be sued. And so what do you have to prove? Well, you have to prove they said it or wrote it, and that it's not true, and that you were damaged. Now, in Missouri, there are certain aspects to it. So if you call someone a criminal, or if you allege someone that has an STD or crimes of moral turpitude, those are often what's called defamation per se. And what that means is you don't even have to prove damages. So if you call someone a criminal and it's not true, you could be liable and the damages are implied. That is, they don't even have to show that they are damaged. So you need to be very careful what you write and what you speak and make sure that it's true. There are some exceptions. You can express an opinion versus a statement of fact. Like, I'm of the opinion that Mayor John Doe is a corrupt mayor. That could be protected by the First Amendment, and it could be protected in terms of defamation for a couple of reasons. Number one, he's a public figure. Assuming Mayor John Doe is a public figure, which he is, and it is my opinion. I'm not stating that he is, and if I have some information that makes me believe that he is corrupt, then I would be able to support that. So the difference for a public figure, quite simply, is, and you may have even seen the movie Actual Malice. For a public figure to be able to bring a cause of action, you have to show that the person speaking, the speaker, had a reckless disregard for the truth. So let's say that I said, John Doe, the mayor, is corrupt and is a criminal. And if I didn't check that out at all, or if I had knowledge that in fact he wasn't, that would definitely be an example of a reckless disregard for the truth. Now here's the reality on defamation cases. They're very expensive to bring. And everybody knows that talk is cheap until you hire a lawyer, especially a good one. So what do you do if you've been defamed? The first thing you should probably do is ask let's say it's on Facebook, you provide information to Facebook or the other provider that this information is out there, and ask them to take it down and ask them politely. Then you can contact the person if you know who they are, who's made the statement, and ask them to retract it. Now if they don't, then you could bring a lawsuit. What's that going to take? Well, you got to hire a lawyer. There's a cost of litigation. Most lawyers on these type cases, they might take it on a contingency fee basis. They might take it on an hourly basis. Let's say it's an hourly basis. Well, a decent lawyer is going to run you $200-300 an hour, and you're talking several hours of work just to get the petition filed. So the deterrence, unfortunately, is that it is very expensive to bring litigation. Here's the other problem. Let's say it's something that's really terrible. So you file this lawsuit, and now this lawsuit is out there in the public eye as well. Because most cases, unless they're extremely sensitive, like adoptions, paternity, things like that, or where you can show some good cause as to why the case should be sealed, are not able to be kept from the public eye. So if you bring a case saying, let's say John Doe wants to sue for that statement that he was corrupt, that's going to bring attention to it. Sometimes it's like rubbing salt in the wound. So again, defamation in the internet age, what are the elements, what are the implications? The First Amendment does protect your right to free speech. It does not protect your right to injure other people when you are speaking. And again, defamation, three basic elements, that is the defaming or untrue statement, and the injury, and that the speaker knew the statement was false. And that is the answer to your question. Thank you.